to get from the ZBA, he's looking to have that approved so that he can add the piece on the other side of the river to his other house. He didn't want to move the line any. This one here. Yeah.
Did he offer an explanation as to why he didn't want to move it?
He just said he wants to keep his river frontage. And he said something about the town should be happy with the taxes. I made it very clear to him what they were asking. And he just said no. So he didn't explain to me 100% why.
Mhm.
He was just adamant about not moving the line.
And why is it that he wants the lot line adjustment?
The house that sits up on the hill.
The new house.
Yeah, he wants to use the road as a natural boundary. This piece of property right here is attached to that and wants to attach it to that, so it's not. So it's, everything on one side of the road belongs to one house and everything on the other side of the road belongs to the other house. But he doesn't meet the acreage requirements by shifting the property line. He's not creating any new lots, he's just trying to improve his 2 lots.
He just doesn't want the road dissecting the one lot. You know, which
Yeah.
would be basically for if he were to want to sell it in the future.
Well, no, we'll dissect the one lot.
Yeah, except, yeah.
Well, it's dissecting it now, he doesn't want
The road already-
to.
He doesn't want to eliminate that.
He
issue
wants to
completely.
eliminate this
Right.
part.
There,
He wants to
right,
add it.
right.
But you still got it here.
Right.
And the ask was whether that could just be made so that
Right.
one lot was on one side of the road and one lot
Mhm.
was on the other side of the road. That was your ask.
And why is it that he did not want to move this line?
He wants to keep some river frontage with his house on the hill with that's the way the deed line is now, and he wants to keep. But like Ken had mentioned, that's all wet area there anyway, but
Right.
you know, it's a.
And you made him aware of that.
Yeah,
you achieved the same thing with
I don't want
the-
to tell you what he said. I mean, just, I made him aware of it and yeah.
Okay.
In other words, in polite mixed company, it's
Yeah.
not something to repeat.
And it does, I always thought, I can see why the board would suggest that, so, yeah.
And if that was to be done, what would be the acreage of lot 23-1-2?
Oh, that's a good question. 100,
Those
it's,
3.5.
it'd be about a half an acre bigger. Yeah, it's about a half an acre, 100 by 200 is roughly a half an acre.
So.
So it might even be a little more than a half an acre.
Well, this, according to this,
It still would be underneath the 5 acres.
Right.
But
Yeah.
it would be, if it was about a half an acre, it'd be 4.5 acres instead of 4.9.
Instead of 3.5 acres, it would be probably just over 4 acres.
Right,
Right,
right.
right. But he wants to keep that river frontage with,
The other lot.
maybe it's something to do with the view, maybe it's something to do with, I don't know.
it's all that wet. It's not like anything's gonna be.
I don't
built
think
on
so,
it
no,
Unless it had stilts.
yeah.
Does anybody have anything else? We'll turn it over to any of the neighbors that want to speak on this.
I'd like to hear it. From your neighbors.
Okay, any folks here show up on this situation on Hankins Road? Nobody? So much for that.
Yeah. Anyone online?
Anyone online? Okay, since nobody's online and nobody in the audience appearing to this matter, then I'll make a motion to close the public hearing on this.
I'll second that.
All in favor?
Aye.
Aye. The motion carries. The public hearing is closed on the Glover application. So call the regular meeting to order.
The United States of America. And to the republic which stands one nation under God, indivisible, with liberty and justice for all.
Did everybody get the? We got the minutes from the last meeting. Did you have a chance to look?
Yes, I read them.
Okay, does anybody have anything to add or change on it?
Not I.
No? No? Okay, so
Move to approve
uh,
something?
I'll second. All in favor?
Aye.
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 Okay, the motion carries. The minutes are accepted. Okay, moving on to old business. John Glover application, 23 Hankins Road, SBL 2312 and 2313.3. We don't really know where the neighbors are on this. But the owner didn't like the idea of consolidating the smaller lot to make it more, or I should say, less of the lot reduction. So. Does anybody want to add to this?
Well, I think that, I don't agree with this lot reduction as if he wants it. I think that we're gonna end up with a little less of a change, which he's not going to agree to, so I think I would just.
Yeah, if we were to give a variance, it would have to be the least amount possible, and there is a way to make that lot line change happen without any issue. Well, it's diminishing the lot by less than what it would be if you didn't ask to include this lower portion. So we would actually be granting, we'd be making a non-conforming lot even more non-conforming, which is contrary to our zoning law.
Correct. Ed, you got anything on it?
I agree with Steve said, simply making a non-conforming lot even more non-conforming in this.
It doesn't sound like, that we're in, any kind of a agreement to approve this. So, that being said, we can make a resolution to, have Ken draw up a resolution and, to deny this application.
And the basis would be, just to make sure I'm on the right page, I think I know where you guys are at, but section 300-11.4, which deals with area variances in the zoning law, paragraph D of that, paragraph C of that is entitled minimum variance. The ZBA in granting of area variances shall grant the minimum area variance that it shall deem necessary and adequate to address the unnecessary hardship proven by the applicant, and at the same time preserve and protect the character of the neighborhood and the health, safety, and welfare of the community. And I assume that's what you guys are pointing to or
Right.
relying on.
Yeah, there is a- Who was rejected.
Okay.
And also, probably the substantiality aspect of the variance.
All right, I will put a resolution together for your consideration at your next meeting.
Okay, and just to, what Neil said, there was an alternative offer, which would make the variance less, and it would not change the viewpoint, of the river from the house. And the fact that the applicant owns both properties, he could very easily grant himself a right of way through that area in perpetuity. So he would not be losing his access to the river.
All right. So I'll make a motion to direct Ken to draw up that resolution. Anybody want to second that? All in favor?
Aye.
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 All in favor, the motion carries. Okay, so that closes that application. On new business, there's an appeal from the Whitens concerning 174 Bridge Street. It's an interpretation on a building permit that was issued in February, and who's going to be presenting this objection or this?
I will, Your Honor, Ben Gailey from J&G.
I'm not at your honor. I'm not at that level yet.
Sir,
All right, well, speaking of which, are you going to be representing them in this action?
yes, Kathy
Okay.
and Brendan Wyden are here and I
All
will
right,
be
so,
representing them.
so we're going on a record that you're the attorney of record on them.
Correct.
Okay, do you have a notice of appearance?
No.
Okay, now, your honor would be expecting to get that.
If you could please stand over at the little podium thing,
Oh, sure.
so the camera gets you in the mic.
Right here.
Perfect.
Okay, go ahead,
Okay, so let me just summarize what this appeal is about.
please.
Has the board had a chance to review the appeal?
I have, does everyone else?
Yes.
Yeah, okay, good, but there's lots of detail, there's lots of documentation in there. I'm just going to briefly summarize it. There's a building permit issued to 174 Bridge Street, dated February 2 of this year, which authorized the replacement of a bathroom in the basement of the building. Also authorized what the building permit says is to add a water closet on the first floor to the existing bath. And then also to add 2 water closets on the roof of the building, which, as you know, has not been approved by the planning board for any use. So we've submitted 10 different reasons as to why the building permit is invalid and, should be voided by the board. And we cited the key zoning law provisions in the code there. And zoning law section 8.1.3 states that the building permit cannot be issued unless there's been the building inspector or code enforcement officer has determined that there's compliance with the state uniform fire prevention and building code. Section 10.0 of the zoning law states that all applications for permits must comply with the zoning law and must be accompanied by suitable plans and documents. I'm paraphrasing these provisions. They're quoted in full in the appeal itself. The zoning law section 10.1 says that essentially that no building permit can be issued unless all other requirements of the zoning code and all required approvals for the use and the construction have been obtained. And then, like I mentioned before, section 8.1.3 requires compliance with the state uniform code before a building permit is issued. And in turn, the state code states that no building permit may be issued unless all applicable provisions of law are met. And any permit issued where the applicable provisions of law are not met shall not be valid. So it's the zoning law, and we also point out in the appeal numerous state building code provisions that we say are violated by issuance of the building permit. But as you know, this board interprets only the zoning code provisions, so that's the focus of this appeal. But it's also important for the board to be aware of those state building code provisions that were violated as well. So the first reason, I want to summarize these briefly, is that the bottom floor of the building is being used for automobile dealer sales, which is unlawful. There's no approval for that. It's not permitted. in that zoning district. And since the use is unlawful, no building permit can be issued for that floor of the building for that use because it's not in compliance with the zoning code, in violation of zoning law sections 8.1, 3, 10.0, and 10.1.7. Our second reason pertains to the building permit, which authorized the construction of the water closets on the roof of the building. And that roof hasn't been approved for any use by the planning board, which is required. So therefore, under the zoning code, it's not lawful to issue a building permit for any construction work to be done on the roof of the building. Number 3 is that there's an inadequate number of bathrooms on the Bridge Street level of the building where the restaurant bar was approved, and that the building permit application does not remedy those violations. So that would remain to be a violation, which prohibits the issuance of a building permit. In addition, there were no construction plans submitted for any of this work, actually. And the zoning code requires that, as well as the town code, the building and construction code. But the zoning law requires that. Our third reason I'm sorry, that was number 3.
Yeah.
Fourth reason relates to there's a sewage pump in this building in the bottom. So the sewage can be pumped up into, up out of the building. And the capacity of that pump, the sewage flow is going to increase significantly with the change from, it used to be just the auto dealer sales on the Bridge Street level of the building. It's now been approved for the restaurant bar. The sewage flow will increase significantly due to that. And there's been no study of that existing sewage pump in the basement to determine whether or not it can handle that increased flow. And in addition, there again, there was no construction drawing submitted in violation of the zoning law and other sections of the town code. The fifth reason there's been unlawful work on the site in violation of the approved site plan. The work done includes adding significant amount of fill on top of the existing surface, which creates a steep slope condition and has extended the parking area on the north and east beyond the parking lot that's shown on the approved site plan. And it's unlawful to do any work in violation of an approved site plan. And in addition, there's been no runoff remediation measures that have been installed. My client owns property directly behind 174 Bridge Street. And so these violations of the site plan have a direct impact on their property. Reason number 6 relates to all the debris behind the property. It's been there since the construction was carried out, still there. I understand some of it has been removed, but there's still debris there, which qualifies this property as a junkyard under the town zoning code.
Folks, please.
Which is a prohibited use at this location. And it's not just that it's a junkyard. All the debris back there has pushed through my client's fence located on their property. It's damaged the fence. The debris also has spilled onto my client's property. Number 7, construction of a new retaining wall and the parking lot encroaching on my client's property. There again, the new retaining wall is not shown on the site plan. Therefore, it's unlawful to issue any building permits for the property. Reason number 8 pertains to the pump station again. There's no plans that we've seen that indicate how the sewage flow from the proposed rooftop restaurant, for which the building permit was issued, will get into the sewer system. Because under the state code, it's unlawful for the sewage from the rooftop back rooms for which a building permit was issued and which we're challenging to use that same pump station in the basement. There's required to be a separate means of pumping the sewage from the rooftop into the sewer system. Number 9 is that there's an internal stairway access in the building between the lower level, the motor vehicle repair level, and the Bridge Street level where the restaurant bar. That type of an access is prohibited by the state liquor authority, and therefore issuance of building permits for the building are invalid for that reason as well. And our last reason that was submitted later than the initial appeal is that signatures on the building permit plans that were submitted by the architect of record don't match his signature on file with the state and don't match his signature on other plans that he's prepared for property owners. And under the state law, that's a violation of the state law. Take any questions you might have at this time.
We are talking about a building permit that was issued for the water closets, right?
Yeah, so February 2.
And you threw in a lot of stuff there that has nothing to do with that.
Those are all reasons under your zoning code that the issuance of those building permits is invalid and the building permit should be void. So they all do relate to that issue.
I don't see how trash and fill has a connection to that building permit.
Because the zoning code states that no building permit may be issued unless the property is in full compliance with the zoning law. And it's not, because the fill and the expanded parking lot violate the site plan approval. That's a violation of the zoning law. So therefore, no building permits can be issued for that site until those violations are remedied.
Anybody have any other questions for?
Accurate. His assessment is
I
accurate.
have no idea what the assessment is accurate.
Well, I would think that, we would really need to see some survey maps and plots to verify the allegations of encroaching on the lot line. First of all. Secondly, building permits are a pathway to compliance. And building permits are a valid means of remedying what are looked at or assumed to be violations of the zoning law. So you can't fix a problem if you don't have a permit to fix it. So the violation would remain in perpetuity.
None of these building permits remedy a violation. They just create more violations.
Has the work been completed already?
We have no idea who our knowledge hasn't been started. I don't know.
Yeah,
It's investigated.
absolutely.
And I'd like to hear from zoning about this.
Well, Mr. David is here representing the 174 Bridge Street. If we're done with Mr. Gailey, we'll
I have one other question. This building permit was issued in 2023.
Yes, February 2, 2023.
Okay.
The appeal was filed March 30.
And when was our new zoning ordinance put into place?
What was last year?
Last year?
I mean, the amendments, it's the underlying zoning ordinance, which is saying that the amendments were effective last year.
So I was looking at our new, and I didn't see any of these sections referenced. I would really like to see how that correlates with both the new provisions and also, how that's incorporated into our zoning law.
Yeah, we looked at both the provisions that are online and the new zoning code that was only on your website, but not yet on E-code.
Because there is, I don't know when it got put up there, but there is a link on the
Yeah,
website
it's
to
okay.
E-code.
It's, yeah. It's
I don't know when, Crystal, I don't know when that went up, but it's.
Yeah, we looked at that.
Because the amendments were done, adopted in September of 2022.
Mhm.
Right,
And as once they became, part of the state record, they were put on the Eco 360 as another link until they finished notifying.
And we referred to those. We've reviewed those.
Anything else to look together?
Neil, can I just ask one question?
Sure.
Neil, is the allegation that their engineered plans, engineer architect, is the allegation that they're forged, the signature is forged?
It doesn't match the
Well,
signatures on file.
so what's the implication of that? It's forged.
Don't know. It doesn't match. Look, the only fact that I know is looking at the signatures is that it doesn't match the signature on file.
Okay.
And doesn't
Who's
match the
making that
signature.
assessment? You are?
Pardon me?
You're making that assessment?
Yes, and my clients. It's obvious when you see the exhibits that we attached. It's obvious what the change, and we explain them in the documents as well. Obvious to me anyway.
And when do you think the original signatures were placed on file with the state that you're saying they don't match?
1986.
So.
It's in there. We showed copies all
Yeah,
the time.
it's not just a matter.
I'm just making this as so that
Sure.
the rest of the people here in the audience understand the questions. So if someone was signing off on official papers in 1986, is it not possible that over the years, which that becomes what, 36 years ago?
37.
We included samples of.
But, you know, the way someone changes their legal initialing and so forth evolves over time. I don't sign my name the same way I did at 18, so, you know, it's very possible this gentleman no longer does the same thing.
We included signatures like each decade, and in addition, we included documents that he signed for us that we filed with this town in 2018. Were plans for a property we had here. So we included those as an example also. Say this is his signature on our drawings. This is his signature on file with the state of Pennsylvania, and these are the signatures on file with the drawings.
I think if you look at the exhibits, it'll speak up.
2018 was pre-pandemic. I know I changed my signature with the pandemic. You know,
I
I
would-
no longer wrote out my name.
Maybe-
I just,
Yeah, maybe not prejudge and take a look at the exhibits first.
I did.
Okay.
I did.
Okay. I'm sure you noticed the differences.
I noticed the difference, and I also noticed that same difference.
Okay.
Just, you know, there's a lot of nuances and a lot of moving parts to this. And we definitely like to hear from Mr. Truman.
Okay, all right, Mr. Davidoff?
I represent Upper Delaware Hospitality Corp. I want everybody to know that though they were the ones who applied for the building permits, we were never served with these papers for this appeal. We happened to find out about it last Tuesday. We're not prepared at this time to address these 10 issues, which are nothing more than an end around the decision of Judge Meadow, which is on appeal, which they have yet to perfect the appeal. They did the same thing the last time. They took a issuance of a CO, certificate of occupancy, and attempted to get around the statute of limitations that they had failed to file timely an appeal from the special use permit that was issued by the planning board. And that's where we are right now. The same thing. How do you not give the applicant a copy? How do you not serve the applicant with an appeal? How do you not let the applicant know that you're coming before a board to set aside something without letting that person know? I'm sorry if I'm getting too loud, but this is just not due process. And it's not this board that did anything. It's the parties who filed this and tried to do it without letting us know that anything was on. And that is just not the way things should run. If there's going to be a hearing, because the law requires that if you're going to pursue this, there has to be a hearing, there has to be notice given, and you have to do it in the proper procedure. If the board is going to undertake to even give this appeal anything, it has to be done properly. And at that time, if and when that occurs, if and when the board believes that they should go forward with it, and if and when the mailings occur, and if and when notice is given, we'll be prepared to prove that this is nothing more than what we already went through and had to go to court and have a judge decide that they had missed their date, and you can't get around that. And you didn't get around it when you attack the certificate of occupancy, and you're not going to get around it by attacking building permits applications.
Just respond to that.
Sure.
First, we have no obligation to notify the property owner. That's the ZBA's job, and I'm sure you'll do that. And in fact, if Mr. Toomey or Mr. Davidoff had not been here tonight, I would have requested this board to immediately send a copy of the appeal to the property owner so they can be prepared for the public hearing, which the board is required to hold. The other comment about this attempt to be an end run around the prior court decision, completely unrelated. These building permits have nothing at all to do with that prior decision. It's a completely new matter. So it's just drama, the false statement. We will request that the board to schedule a public hearing at the June meeting, if you would, and to be sure that that Mr. Toomey and Mr. Davidoff have all of the documents that we've submitted to the board already, so they can prepare for that hearing.
And I'm just bringing forward, excuse me,
Miss-
information.
No, this,
I submitted, this is documents I submitted today. I owe you copies.
of the one that you left with the new application? That's the new,
You can get that to Matt.
Oh, okay, I send information today and I brought the copies.
oh,
That's all I'm
today,
saying.
that's
Yeah.
something else now.
Yeah, it's additional information. I have the copies. That's all I'm saying. Okay.
If we move to a public hearing, is that enough time for you, Mr. Davidoff, or would you like another appearance? To prepare,
Today.
not today, no, not today.
I don't,
I mean, for the June meeting,
Mr. Chairman, I haven't seen, I'm sorry, I don't mean to interrupt you, and I appreciate what you're saying. Well, I don't want this to go on any longer than it has to. And I don't think that the application has been duly presented, whereas there even should be a public hearing. I don't think it's sufficient for the little amount of the time that I had to look at it. I don't think a public hearing should even be scheduled because it's totally has nothing to do with the building permits that were issued. However, to answer your question directly, the June meeting would be what? That would be sufficient if in fact a public hearing is scheduled.
so would you want the public hearing that day, or would you want that meeting to this time to prepare for it and present?
No.
12.
No, the public hearing could be, if you're going to proceed with a public hearing, that day would be fine.
Well, I think in this situation, I think we should hear what the public's thinks about this whole thing.
We can tell you right now.
No, it doesn't work that way, I'm sorry. So, I understand your position, I understand Mr. Gailey's position, and so does anybody have anything else for Mr. Davidoff? Does anybody want to make a motion to set this down for a public hearing in June?
I'll make that motion. For the seventh?
At 7? Yeah, probably. Yeah, okay, all in favor?
Aye.
Aye. Okay, all in favor, the motion carries to move this to a public hearing on June 12th? At 7 PM. Is that okay with everybody at the time?
Yes.
Mr. Davidoff, Mr. Gailey,
Yes, it is.
7 PM? Ken? Okay. Also, before we close, the Whitens submitted, you guys got the digital versions of the last one. There was a submittal of some more evidence and a letter that was submitted. And
Or the one about requesting a
No.
lawyer.
no, this was a letter to some newspaper.
Oh, the letter that was in
It
the
was-
Democrat?
I don't know where it was in. I don't know where it ended up, but it was addressed to the editor. It
Yeah, it was-
copied us. All right, so I forwarded that to you guys, digital copies. I didn't get the hard copies on that. I only have one hard copy.
Okay.
All right, so,
Yeah, I read it on that.
all right, okay.
Mr. Chairman, rather than have to foil everything and spend additional time, may I ask that, the, board, the ZBA direct, the applicant, for the appeal to provide us with copies of everything that they have provided the board, so we can move this along?
I think that's,
I think it's
that would
better.
normally be a courtesy, wouldn't it, Mr. Gailey,
I
at the
know
very
we're
least?
doing that, but I think it's better if the board were to send that to Mr. Davidoff. That way there can be no question that perhaps I by mistake didn't send him everything. I prefer to have the board do that.
I've never heard that before, Mr. Gannon. You know, I mean, lawyers provide the other side with what they give to a court or to a
Right.
board. It happens all the time.
That's the rules of discovery, isn't it?
Yes, Mr. Chairman.
If you want me to do that, that's fine. I have no objection. That's fine. I just think it's better all around with my suggestion, but I'll do it.
Well, you didn't exactly do a good job when you said, when we got it from your clients. I mean, you got stuff delivered to us in fragmented fashion. You got stuff to mail to the board, which is highly irregular.
We wanted to be sure that all the board members had that well in advance of the
You
meeting.
could have done that by doing it the normal channels, you know. that.
No, on the appeal we made last year, even though we got it in well in advance, the board members didn't receive it until the night of the meeting, but we wanted to avoid that this time.
Well, if you can get all the documentation to
We'll
Mr.
do it.
David off.
Yep.
Before the June meeting, that would be
No, I'll get it to him within the next day or two.
great.
Thank you, Mr. Chairman.
Okay. Okay, so with that all being said, does anybody want to make a motion to close the meeting? I'll second that. And all in favor?
Aye.
Aye. Okay, most, all is in favor, motion carries, the meeting is closed.